Hello and welcome to another episode of Litigation Insights by Law Learning Bench. I am your host, Advocate Rishu Yogesh Pandey, along with Advocate Divyanshi Bansal, and today we have the honor of speaking with Senior Advocate Mr. Vikas Singh. Distinguished guests, young lawyers and all our online viewers, a warm welcome to you all. Before introducing our esteemed guest, I would like to give a brief introduction about our platform. Advocate Mithilesh Kumar Pandey, founder of Law Learning Bench and managing partner of Supreme Law House LLP, has brought this landmark initiative that brings together the highest echelons of the legal fraternity to inspire, empower and guide the next generation of advocates. Law Learning Bench has launched the Advocacy Skills Development Program, an initiative designed to equip budding lawyers with practical courtroom skills, ability to listen attentively, ethical grounding, communication excellence, and exposure to emerging areas of law such as cyber law and international legal systems. Today's panel is an important step in that direction. For the purpose of enhancing advocacy of first-generation lawyers, we are also in process of entering in MOUs with the British Council and international law firms. We are taking all the necessary steps to develop key skills like communication, empathy, critical thinking, out-of-box thinking, problem solving, client handling, professionalism, learning of judgments and interpretation of bare acts. Today, we have Mr. Vikas Singh, Senior Advocate, Supreme Court of India. The name does not need an introduction as he is not only a towering figure in Indian litigation, but also a mentor to thousands of young lawyers. Many first-generation lawyers like Sir look up to him as an inspiration in believing that hard work and legitimate efforts into this profession can actually make you achieve great success, and you do not need to come from a great background to be on top. Sir is not only a great lawyer, but a great mentor as well. Sir was designated as Senior Advocate in the year 2004. He was the Additional Solicitor General of India from the year 2005 to 2008, the former President of the Supreme Court Bar Association. Sir is also a visiting faculty member of the Parliament of India. He has addressed important legal, public and administrative issues as a guest on numerous public forums and television shows. He is regarded as a bold personality who takes a strong stance on concerns of law and justice, and with the same zeal and support from the bar, he is again contesting the SCB elections for the post of President. Today, we have received hundreds of questions from various corners of the country, and our 1.5 lakh viewers, which includes law students, young lawyers, lawyers from small and far away towns who do not have access to material resources to learn practicing law. Due to time constraints, sir, we have selected a few questions which would go on to clear the doubts around the base of advocacy. So, sir, we shall begin now with today's session. Sir, every journey begins with a choice. For many students, choosing litigation over corporate or academic role is a tough decision. Majority of budding lawyers or law students who come from a faraway town, they do not have access to great resources. So, sir, my foremost question to you is, what drew you towards courtroom litigation, and how did your initial years shape your decision to continue on this path, and what all difficulties you had to face?
So, I'm a first generation lawyer, as you yourself pointed out, and I didn't have anybody to back me up in that sense. So, I came here and I joined Mr. L.R. Singh. He was known to me from before. He'd done some family matters. He welcomed me immediately. My foray then into litigation was because I had already done a job, and I had left a job and come. So I didn't want to do another job. So I started in litigation because that is what I had dreamed of at some stage of my life. When one of my childhood friends' family I used to visit, whose father was the Chief Justice of the Patna High Court, and that is my exposure to the legal field because there was nobody in my family. So when I came here, I started practicing as a lawyer, and while I was with Mr. L.R. Singh, or maybe a year or two with him, I had the occasion to get a assignment with the Oberois, and they wanted to take me as an in-house counsel. And I said I can do your advising, but I can't join in-house. And the offer that they gave me with only 1 year of practice was that you think or dream of what you would be earning 10 years from now. And you quote that salary today, we will start with that salary.
Right.
And I remember I walked off saying that I've left a job and come, I'm not going to do another job. So it was very clear that I wanted to be in litigation, and that is what I was meant for.
Sir, thank you for your insight, sir. So, as we were talking about the difficulties that young lawyers face, I personally believe, as well as my colleagues with whom I have been working and with whom I have studied across. So all of us say that many young lawyers, they experience anxiety before their first courtroom experience. So can you describe your first courtroom experience and what was going through your mind and how did you prepare for that particular day?
So my first courtroom experience has been very, very different from probably anybody else in the legal field. So I had done about 9 years of a job in Steel Authority of India Limited, and I resigned and I started practicing. And I remember this was in June of 1990
Sir.
that I put in my papers and I resigned, and I got enrolled sometime by the end of June 1990. And July, the court was to reopen for vacation, from recess after the summer vacation. So after having resigned, I suddenly, started feeling very nervous. And I told Mr. L.R. Singh that as a schoolboy, I remember when I tried my hand at elocution,
Sir.
I remember my feet used to shake.
Yes.
So I said, I don't know whether I'll be able to argue. And by that time, I'd already burnt my board because I'd already resigned.
Sir.
So to, overcome this, on the very first day of my life in court, that was the day of reopening of Supreme Court,
Sir.
he gave me 3 matters to argue in Supreme Court
All on your
the
own, sir.
first day.
Yes.
And I remember my first matter was before Justice Venkat Chalaiya. He was sitting in court 6, if I'm not mistaken,
Sir.
or maybe 8. And since I was not used to saying my lords, I was saying sir because I was in a job. So I kept on arguing as sir, sir. He heard me very patiently, and when he wanted to dismiss the matter, he said, sorry sir, and he kept the file in front of me. So I said, sir, but I have to say something else. So he picked up the file again, and then he heard me again. Ultimately, he dismissed the matter. But that's how I got over my fright. So there was no looking back thereafter.
So basically, you are saying that we have to make an attempt to overcome that kind of anxiety in a courtroom experience, right, sir? So the next question, I guess Divyanshi has to.
Yes, sir, I want to add on to the answer you gave. Sir, as you saw that your matter was dismissed. Sir, in that specific aspect, as a first generation lawyer, we might come across certain clients who want that their matter should be, their matter should be allowed, their appeals or whatever they are filed, they should get the relief. But sir, in that specific circumstances, how do you handle your client? Although you know that the case was not maintainable or there is no merits in the case, but the client, as a first gen lawyer, it's very difficult for us to make sure that our client believes in us. And sir, most probably they'll also come up that you were not competent enough. So sir, how do you deal with that specific aspect of telling your client, understand the fact that your matter does not have any merit?
So there are 2 parts of this, So when you get into litigation, there are 2 things which are very important for you to succeed as a lawyer. One is that you have the empathy for your client and you feel his problem is your own problem. Ultimately, especially in Supreme Court, client gives you a brief and goes away and he's not even there when you argue this matter. Most of the time he doesn't even hear what happens in court. So that is the first thing. So you feel his problem. But every problem doesn't have a legal solution. So you have to give a legal shape to the problem. Now, if you think that there is a clear legal shape covered by a judgment of the Supreme Court, invariably you should get relief. But there are times when you feel that a client doesn't have a clear-cut case. There are 2 aspects of every matter, and there is a possibility for a judge to take a different view depending on what line of judgment he wants to follow and what line of judgment you want to follow to support your case. So those borderline cases, of course, you have to tell your client before that these are the. So when I say that you have to give legal shape, you have to do that kind of research in your client's case and explain to him how the law has evolved over that particular issue that you want him to argue or he wants you to argue, and tell him that these are the 2 sides of it. In fact, I'll tell you something even more interesting. My success in this profession has not been for what cases I have won more, but more because the people have told that you don't have a case and no point of spending money in a lawyer.
Sir.
Because when a client is coming to you, he's ultimately ready to pay money. And if you say, sorry, there is no case for you, And if you return the brief, he realizes that this fellow is not hankering for money.
Yes.
He feels that, and when he goes to some other lawyer who makes him file the case and then the case gets dismissed, then he realizes that I got that genuine advice from that earlier lawyer.
Sure.
And that's how the word of mouth spreads about you. So it's not always in your victory that you get, recognition. In the proper advice that you give to your client is a more important recognition which holds you in the long run.
So, sir, since we have talked about, what the courtroom experience of a young lawyer could be, sir, I would also like you to give some of your insights on the briefs. Sir, you have been a filing counsel and arguing counsel, senior advocate, ASG. From starting to end, sir, you have seen almost every aspect of being a lawyer. So, sir, could you walk us through your approach to preparing a case file from research to note making through structuring the oral arguments and including all those in the pleadings? And sorry, sir, to add on to the same question, how would you define the same question, how would you answer the same question from the bar's perspective as well as from the bench's perspective, sir?
So, preparing a case is according to me, it's a lot of multitasking.
Yes.
So, the first step that you have to do is to master the facts.
Sir.
And when I say master the facts, you have to master it chronologically, how things happened over a period of time.
Yes.
Then you have to realize what branch of law is involved.
Sir.
Whether it is Contract Act, whether it is Specific Relief Act, whether it is narcotics control if you are doing with criminal matters, or whether it is the Indian Penal Code,
Sir.
or the CRPC, whatever is the law involved in that. And then you have to do a research on the subject where your question of law is arising for determination.
Right.
Because every time there is especially in the Supreme Court or rather higher courts, it has to be more of a question of law. Factual
Yes.
questions got decided in the lower courts
Yes,
only. And once you've done the research for the, so when I say so I remember when I did my first civil suit in the Delhi High Court, I remember drafting a civil suit. I used to go to a clerk by the name of Mr. Khurana. He's not there anymore.
Sir.
Used to be a bearded clerk. He had a cat next to him. He used to sit in the typist pool.
Sir.
And I remember I sat with him and he taught me how to draft a plaint. He taught me what are the essentials of drafting a plaint.
Sir.
So you should be ready to learn.
Sir.
And law is such a vast area of knowledge, requirement of knowledge, that if you start thinking that you know everything, that's the day you're doomed.
Sir.
Nobody can claim, even a Supreme Court judge or a Chief Justice cannot claim to know everything in law.
Sir.
So every day is learning for you.
Sir.
So I would say focused learning is important.
Yes, sir.
Whatever is your area which you want to do, which is the subject before you, your client's problem, that kind of focused, it's like doing, and the more higher court you go, so for instance Supreme Court, if you want to survive in Supreme Court, you should be ready to do a PhD every night when you get a matter for a different subject.
Sir.
If you are not ready to do that kind of hard work, then this is not the right place for you.
So basically you are saying, sir, making yourself thorough with the entire facts, the entire applicable
Entire
law,
law.
whatever you want to argue and whatever the judge could ask from you. Yes,
please keep in mind, or everybody should keep in mind, that your client should never suffer because of your lack of preparation or your lack of knowledge.
Right, sir. Right, sir. That's wonderful, sir. Yes. So
I have two questions in this regard. Firstly, that as you said that your client should never suffer. So sometimes as a young lawyer, we tend to prepare, we tend to over prepare also, and we are very prepared. But sir, certain times it happens that there is certain things which, like a senior advocate, like every time it's said that a lawyer knows his facts and his brief very well, but a great lawyer is one who knows the judge very well. And sir, as a young lawyer, we are right now on that journey that we are trying to understand the judge and how his mindset is, how is he working. Sir, sometimes in that kind of situation, we tend to fail. And so we are not able to decide exactly at what specific time, what specific answer should be given. Although we are thorough with our facts and law and everything, but the judge wants us to go in a certain direction. And sir, that's the difference basically between a senior advocate and a young lawyer. So sir, how as a junior lawyer, we should tend to overcome that gap and make sure that our client doesn't suffer because of all of this?
So when I joined this profession, I used to know Mr. Lal Narayan Sinha, who was one of the Attorney Generals of India, and he was known to our family. So I once was just discussing with him as a very junior lawyer, I just started in the profession. He said, you should never show your client the house of a senior advocate.
Sir.
If the client wants a senior advocate, do take him to the senior advocate. Don't yourself. You should always be ready to do your matter yourself. That's the first lesson. But having said that, the second lesson is a more difficult part of that lesson. And when I say more difficult part is because if you want to, get the advantage of arguing like a senior advocate, then you have to be prepared also like a senior advocate. And when I say prepared like a senior advocate means that you should know, even for instance, there is a particular section, how that section has evolved over a period of time, how it was interpreted in this manner and why it was interpreted differently later, how thereafter it has again. So that kind of research you should be able to do. If you are ready to do that kind of research, you will be as good as the senior. So when a judge asks you a question, you would be ready with the answers.
Yes.
You can say that no, this section has since been amended and this is how the latest interpretation is, or sometimes there is a latest judgment which you are able to show. So that preparation is required. Ultimately, if you are ready to do that, I don't think you will be any less than a senior advocate.
Sir, my second question was, as you said that we all should, young lawyers should have a focus learning. But sir, the issue which we face with the focus learning is sometimes I am somebody who wants to specialize in civil law, but the client I have is somebody who's coming up with to me and saying that I want you to quash my FIR. So sir, I also want to do that matter, but however it is going out of that specific focus learning. So sir, how should I align my goals with my focus learning, and also because I have to cater to every client which is coming to me. So how should I?
So when I started in the profession, I was doing only civil cases. I didn't used to do criminal cases. I didn't even read the criminal reports. It's only at some stage of my life when I got a matter of somebody known to me, a criminal case, and I sent it to some other lawyer. And when I was, accidentally watching that case being argued, I realized that it was mishandled. That I realized that no, I should also do criminal cases. And now I also do criminal cases, not that I don't do civil cases. I've given up civil cases. But when you do a different branch of law, as I told you earlier, the jurisprudence of criminal law is very different from civil law. The preponderance of probability test which is applied in civil law doesn't apply in criminal law.
Yes.
The onus is very different in criminal law.
Sir.
Onus is on the prosecution to prove the guilt. So here the onus is very different. So that fundamental of criminal law you have to understand before you take a criminal case.
Sir.
So I remember my first cross-examination that I had to do in my life in an arbitration. I didn't do it. My first cross-examination was not in a civil court. I remember overnight I read a full textbook on cross-examination.
Sir.
And one of the very important lessons that I learned in cross-examination was in that overnight learning that it is important to know what not to ask than what to ask.
Sir.
In cross-examination. You end up asking questions sometimes, giving the advantage to the witness to explain things which he has not explained in his original statement, which you can use against him.
Sir.
So that's why I say it's a wonderful profession. People invariably see our success, but they don't see the kind of hard work that we put in to get to this wherever we are.
Oil burning.
That midnight oil burning.
Sir, since we were talking about clients and hard work, so a very crucial aspect of being a lawyer is negotiating fees, and this is a very tricky area. And including me and many young lawyers, we all aspire to charge very hefty amount of fees, running it into lakhs and crores, looking at the figures that we hear on everyday basis that see some senior advocate is charging this much, that much. So, but what I believe is most of the young lawyers, they fail to comprehend the fact that the concerned lawyer who is charging such hefty fee did not started charging that fee immediately. He had to strategize his entire life, his or her entire life. He had to work very hard, put into some smart labor. So, sir, my question to you, sir, when you started independent practice, how did you decide what to charge your clients, and what advice do you have for young lawyers who are in a very similar situation?
So, so what you charge is actually a very personal issue of what you feel that you charge. I remember my senior, he was very bad at charging fees. And I remember I used to sit on the other side of the table and client used to sit on my side.
Sir.
And my senior used to sit on the other side. The fees he used to quote, I could see my client, giving from his bundle, taking out a 1/10 of what he had brought and giving it to my senior. Point is not on the question of money. Point is that how you value yourself.
Yes, sir.
If you don't value yourself, nobody else will value. So whenever I've had clients who say that there are people who are ready to do this work at a cheaper cost, I always tell them, please go to them.
Good.
If you want quality work, then you have to pay this kind of fees.
Excellent.
It's how you feel that kind of work that you do, or the kind of effort that you put in
Sir.
to get him justice. How you would value that. I remember first time when some client used to tell me to go to a senior advocate, I always used to charge them to go to brief the senior.
Yes.
Because it's a lot of wastage of time.
Yes.
Then there was no virtual briefing.
Sir.
So you firstly go to the senior's house, wait there for hours, get a time, brief him, and then come back, and then you waste the time again coming back. Your time is being used.
Yes, sir.
So if the way to charge money is that firstly you have to respect what you do.
Yes.
If you feel that I am doing good work, I am doing hard work, I am actually doing the kind of genuine drafting and
Sir.
research, etc., everything, then you charge fees accordingly.
So the kind of labor you are putting in, you have to judge first yourself, and then
only
you have to show it to the concerned client that yes, I am putting in this kind of efforts in your
Absolutely.
case.
And he's coming to you invariably with some reference. There is no roadside nameplate on the basis of which a lawyer's engagement is always through reference.
Sir.
Somebody must have referred
Yes.
you to him.
Sir.
So whoever must have referred to you to him must have also told him that he's a hard-working lawyer,
Yes,
and he really puts in his
So
work.
basically, again, coming back to what you earlier said, word to mouth basis.
Absolutely.
So since you were telling us about the scene that you are working with a senior advocate, and you are also a senior advocate now, sir. So the part to becoming a senior advocate involves really hard dedication and recognition over decades, sir. It's not a one-day job. So, and the amount of struggle, the strategy making it takes must have been a very long process for you as well, sir, as well as for others. So, what my question is, sir, at what point did you realize that you were building a name that would lead you to the designation of a senior advocate?
So as I told you, because I started my career with my first day arguing 3 matters in Supreme Court,
Sir.
I had in that sense a dream run. My senior used to permit me to argue his matters,
Sir.
and he was happy doing the drafting part.
Sir.
This is very rare. This
Very
doesn't
rare,
happen.
sir. Yes.
I don't think anybody can claim to have started
Yes.
arguing from day one.
Yes, sir.
So slowly I started getting people to brief me also, even as a junior. So I was in that path from the beginning, and that is why my journey to become senior advocate became much easier.
Much easier, sir. Right, sir.
Sir, I wanted to ask a question specifically with regards to AORs. Sir, we have seen that people are obviously giving the exams and everything, but sir, some young lawyers who have that kind of practice, like they are working with a senior who is working in Supreme Court and they know the nitty-gritties of Supreme Court, sir, but they themselves don't have that kind of clientele which can actually give them work in Supreme Court. Sir, should they also pursue becoming AOR in that sense?
Firstly, AOR doesn't get you client.
Sir.
That you must remember. I was never an AOR, I never took the AOR exam. So an AOR doesn't, even if you are an AOR, doesn't mean that you will get clients. Clients come because of your reputation for doing hard work and your sincerity and your empathy for understanding the problems of a client. If you are an AOR, you just have the advantage of being able to file it yourself. If you are not an AOR, you get so many AORs who are ready to file it for you. So that's really neither here nor there. I don't think taking an AOR is an asset for the purposes of getting a client. Becoming an AOR can be an advantage for panel work. There are state government panels or central government panels or PSU panels who are who have a requirement of an AOR to be impaneled. So that may help you there, but those are all according to me not something for a visionary lawyer. I will say that's more of a short-term relief.
Sure.
So,
So nextly, I wanted to ask you, do you believe it's possible today for a first generation lawyer from a small town or a middle class background to succeed in litigation, and what are the essentials for this?
So, as far as first generation is concerned, I am myself a first generation lawyer with no backing. I really didn't have much of monetary backing also, because when I had left my job with Steel Authority, I had about 70,000 rupees of provident fund collected, that's all. And that too, 35,000, I remember I bought the SCC, so that also was spent. I used to travel, while in Steel Authority, I used to fly for official work. I remember when I started as a lawyer, I used to travel second class or third class, whatever, then sleeper class with family. I remember once I've been going to Tirupati every year. I remember the first year as a lawyer, I went from Delhi to Chennai, 3-tier with both my small 2 sons. From there, I remember going by bus. So you have to do all that sacrifice, that I don't think makes any difference. Whether you travel in a Mercedes or you travel in a bus, you can still put in the same amount of effort for your client. So I really don't think being from a middle class family or a small town is any disadvantage for hard work. Anybody can do hard work. If you don't have your own books, you can go to a library. And now with these online portals available, now research is so much easier than what it used to be in our time. In our time, we used to have to look at books and find out the right book, look at the digest. Now you can just get everything on a click of a button.
Sir, since we had the privilege of hearing from you about your first case and which ultimately got dismissed, sir, every lawyer has a victory that they never forget, and usually the one that earns them a very big recognition as well. So what was your first major courtroom victory, and how did, in your view, it changed your trajectory towards your path of becoming what you are today, sir?
So I remember I was the additional Solicitor General and the Environment Secretary was very disturbed that Supreme Court was wanting to appoint members to the Forest Advisory Committee.
Sir.
And he came to me in my office in Defence Colony, and he was worried because they were all activist oriented.
Sir,
and if you have
right,
fully activist oriented, then you can't get any clearance.
Yes.
And you have to have a balance.
Yes, sir.
You have to have an activist, you have to have an industry person, you have to have a general person to give a
holistic
get a holistic view. So he said, I don't want this panel. I said, if you don't want this, you will not get it.
Sir.
He said, how? I said, of course, I'll get it done. So I was appearing before the bench of Justice Vikas Singh. He was then the Chief Justice of India.
Sir.
And he gave me that list of 3 names and he said, you issue the notification. I said, you can't tell me what notification to issue. He says, what do you mean? I said, it is the prerogative of the government to decide whom it wants to appoint.
Sir.
It's a sovereign power.
Sir.
It's not something which the court can dictate.
Yes, sir.
So he said, you think so many Solicitor Generals and Attorney Generals have come and they have never questioned our right to appoint members to the committee, and you say you can't appoint. I said, yes, you can't appoint. And I had prepared, I was ready with all those judgments on separation of powers.
Sir.
And I remember he was completely taken aback. Ultimately, we appointed our own panel.
Sir.
It was a big news then, because for the first time somebody had taken on the Supreme Court head on.
Sir.
And I felt very happy having taken that stand on behalf of the government and succeeded.
The courage it took to do all this stuff, sir, must have been a really great enthusiastic feeling, sir. So with regard to the same, this win and your another big win that we all talk about is you being the former president of SCBA. So starting with being a filing and arguing counsel, then becoming a senior advocate, then ASG, and also you have balanced litigation with leadership, such as your role being a former SCBA president. So how do you manage the responsibilities of high pressure litigation alongside representing the bar and advocating for the legal community?
So, at some stage in your life, you feel that you also need to give back to the system in some form or the other.
Sir.
Now, giving back to the system for a lawyer is is very easy by giving it through the bar association,
Yes, sir.
because then you can at least try and improve the lot of your
Sir.
fellow lawyers by working there.
Sir.
And in all my tenures, I've tried to do the best I can for my fellow men, and that is why they all respect me, and that is why I get elected. So I think it's one way to, while continuing in your profession, to do something in society,
Sir.
and to be able to give back to the system. So I think that's one way of,
Sir.
my way of rather
Right, sir.
doing my little bit for welfare of people.
Definitely, sir. So, many young lawyers today, they feel stuck, and they basically have this apprehension that they'll not be able to find the right opportunities which would make them push harder in their career, neither the opportunities nor the clients. So, sir, for young lawyers who are struggling financially or who are unsure of their progress, what would your top practical suggestions be to build visibility as well as clientele?
So, of course, now things are very different from in 1990 when I started. Now there are a lot of online visibility, and there are a lot of social platforms, social apps where you can get visibility.
Sure.
But ultimately, bottom line is hard work, and bottom line is word of mouth.
Sure.
So I feel that as a young lawyer, probably what you can do is, or you can do a lot of pro bono work. Pro bono work gets you the opportunity to at least
Sir.
do the work, and at least show that research and do that research and make your name. I'll tell you honestly, I don't find very many lawyers who are ready to get into that kind of nitty-gritty of finer details.
Sure.
They're more interested in earning that fast buck,
Sir.
but not doing that hard work. Anyone who's ready to do that detailed hard work
Yes, sir.
is bound to succeed.
He or she will be able
He or
to
she
get
will.
into the difficulties and technicalities, right, sir?
So criminal law is often considered as the most demanding area of practice. So how did you decide that you want to pursue criminal law? And so what were the challenges and reward does it offer than the other branches of law?
So criminal law, as I told you earlier, I didn't start with criminal law.
Yes.
I started doing criminal law sometime later in my life. Criminal law, the biggest challenge in criminal law is that if you represent a client who is in society considered to be somebody who's done a grave wrong,
Sir.
then people judge you that why are you representing that X,
Yes, sir.
Y or Z,
Yes, sir.
without realizing that he has a fundamental right,
Right.
to be
sir.
represented.
Sir.
And secondly, to convince yourself or to convince people around you of a case, you have to tell them that ultimately what you're doing is not that you're not a judge. You don't judge your client.
Yes.
You only represent whatever is legally permissible for you to represent him and get him at least justice. Because in criminal law, it's the job of the prosecution to prove guilty. It's not your job to prove yourself innocent.
Right.
So that explanation actually is able to answer most of the criticism that one faces.
Sir.
I have to ask you this particular thing, that how do you draw that line between presenting things in a very balanced way, because you have to, in criminal law, you are supposedly representing a terrorist. So you have to be, obviously you have to tend to make sure that all your defenses are taken up, but you're also the officer of the court. Sir, how do you balance that kind of neutrality and get that neutrality in the sense that you're there and you're able to answer your questions of the demands which your client has raised, and also make sure that you're representing him as an officer of the court?
So when you're representing a terrorist, ultimately even for a terrorist, the fact that he has done something or the proof that they have to establish that he has done some wrong is to be provided by the prosecution. Now, if that prosecution evidence is not stitching up, or if there is some loophole in the evidence, or if you can establish that this evidence cannot lead to conviction because there could be a loophole which is not looked at, then that is the way you get relief for your client. It's not as if you are trying to prove him to be innocent. You are only trying to prove to the court that the prosecution has not been able to establish his guilt. And if he has not been able to establish his guilt, he has to get the benefit of doubt. And that is why your job is not really to, prove him innocent. Rather, your job is to show that the prosecution has not been able to prove him guilty.
So since we are talking about criminal law and back and forth, the questions have been framed to you. So many of our audience as well. So we had actually asked our audience to send us the questions that they want to know from you. So one of the most common questions that they asked was with regard to the bail arguments. So they ask that when a judge interrupts during a bail hearing, saying that counsel, you are going on merits, you are arguing on merits, you argue on bail. Show me why are you entitled for bail? So what specific reframing techniques can advocate use to effectively counter their argument within proper boundaries with respect to these bail applications?
So invariably judges do this if they don't want to give bail. If you want to argue on merits, they will say argue on bail. If you argue on bail, they'll say argue on merits.
Yes, sir.
So you have to juggle in this.
Yes, sir.
Now you have to be prepared for both.
Yes.
When you say argue on bail, you have to say that he is not likely to run away. He is, having deep roots in society.
Sir.
He has if he has a medical issue, then he needs to be given bail for that reason. If he has no antecedents, then that is a good ground for bail.
Sir.
As far as the merits is concerned, of course, is the merits of that particular case, what are the accusations against him and whether
Sir.
he can be said to be guilty or not. So you have to be prepared for both, because the judge will, do a ping pong with you.
Sir.
If you argue on merits, he will take you to bail, and if you argue on bail, he will take you on merits. If you're not prepared in both,
Sir.
then you are in trouble.
So basically we have to go through that struggle each and every time. There is no fixed and hard and fast rule to distinguish,
there
sir.
is no hard and fast.
Sir, a similar question on a similar line, sir. In what ways can advocates effectively use pace, emphasis and strategic pauses in their oral arguments to enhance persuasiveness without being, sir, theatrical or let's say dramatic?
So this is something which is very personal to every lawyer, I would say. Many a times my client asked me or my juniors asked me, sir, how will you start? I said, I also don't know how will I start. So it's not something which you can plan in that sense. But yes, clarity in what you are saying is very important. Even your diction should be clear, because you have to realize that you are arguing a matter before a judge who may not have read the file as thoroughly as you would have.
Yes, sir.
So the clarity, and you have to also realize that if he has no knowledge of the facts of the case, then you have to go a little slowly on facts and explain the facts to the judge. So these are all, things which you have to go on your feet, as they say.
Sir.
I know when I go to many high courts, I see judges don't even read the files. Arguing before a judge who has not read the file is very different from arguing before a judge who has read the file. So these are all, you have to take a call on your feet when you are before
So you're saying
judge.
that there are many factors which would affect how you argue, and basically you have to read the courtroom. You have to know about the judge, whether what kind of
judge, in the sense that you have to see his body language.
Yes, with respect to the court.
What are his questions?
Right,
what are the doubts in his minds?
Right, sir. Right.
That if you ultimately have to get an order from him, so you have to get that cleared before you get go any further.
Definitely, sir. So, next question. Do you have a question?
Sir, I wanted to ask a specific question that as a lawyer, we tend to have a lot of setbacks in our career, and as we go on progressing, obviously, if we take like 10 steps ahead, one step we have to take forward. So, sir, in all those situations when there are a lot of setbacks which are coming our way, sir, what were your coping up techniques with? Obviously, hard work is one thing, but sir, generally, how did you cope up with, if you like, how to get better, how to be there, and sir, how do you have that strength that I lost this matter or something really bad happened or these kinds of setbacks happen, then how do you get that courage to next day go back to court and be there to go further?
So my way of managing stress was very simple. I used to go and play tennis, and after court work, I used to play tennis, and I used to feel that I've finished off the whole day and start on a fresh day after my tennis. But as far as the stress is concerned, basically you have to take the client's call as if you are arguing for him while you are arguing in court. Outside court, you have to again separate yourself from the client, because if you don't do that, it will have a emotional trauma on you.
Sir.
So, do you have any specific message you want to give to our viewers who are the first generation lawyer, how to handle the stress of litigation?
So I feel that stress comes most of the time because of your lack of preparation, or because sometimes when you feel, if you are conscientious, if you feel sometimes that your client could have got relief if you had prepared better, or if you had argued this, or if you had not argued that. So to overcome that stress, I think, you know, every I would say case is a learning point to do better in your next case. Losing and winning is all part of it. You don't have to take it to heart, as long as you have the satisfaction of having done your research properly and have argued the matter properly.
Sir, I have another question for you, and then I'll proceed to ask the last question that we have for today. So this question again was a very common question that our audience had posed during the past week. So what they had asked is how to find mentors in litigation, what to look for in a mentor, and they say that people usually run to look for a great chamber or seniors, and then they feel disheartened when they do not get the particular job they were applying for. So what advice do you have for this, sir?
This is again a very tricky subject, because getting a good office is not so easy today, because there are so many children going around looking for a job, and everybody can't get a job of his or her choice. But I would say perseverance matters. If you feel that a particular lawyer is the right person to be with, and I've seen people who persevered and, you know, win after him. At some stage or the other, he gives you an opportunity. And if you are able to prove yourself in that opportunity, you also land up with that job.
So keep trying until unless you hit that that target that you wanted to achieve. Sir, coming to the last question, sir. Sir, legal education in India still emphasizes on theory more than the practice. With regard to the same, so what specific modules or training do you believe must be integrated into our legal education to produce courtroom ready lawyers from day one?
So in our time there used to be no, you know, internships, etc.
Yes,
no mandatory internships. So now there is a lot of mandatory internship. But what I see in these internships, and a lot of these children come to me, they really don't gain much in internship as far as the you know, the practical experience of courtroom work is concerned. So I personally feel that ultimately only happens after you become a lawyer. So ideally they should reduce the law degree, because if IIT can be in 4 years, I don't understand why law should be 5 years after school. In fact, there was a petition which I argued yesterday, and I feel that it should be 3 years of law after school and 1 year of only practical training, where you should be permitted to do drafting, but you will not be able to file a wakalatnama. And then you make a lawyer ready for this thing. But unfortunately, our bar council is not looking at this so intently. And if the bar council really does this job, then things will.
So with you as our leader, we hope that some reforms are made very effectively and very soon. So with this, sir, this session comes to an end. Thank you so much, sir, for this truly enriching conversation. Your journey, your mindset and your practical advice will serve as a guiding light for every young lawyer listening to this session. For our audience, if you found value in this discussion, don't forget to subscribe to Law Learning Bench on YouTube and check out our app for upcoming courses and mentorship sessions. Until next time, stay curious and keep learning. Jai Hind.
थैंक यू
सर। एक क्वेश्चन मैं पूछना चाहूँगा। सर, आप सीनियर एडवोकेट हैं और आप सुप्रीम कोर्ट बार एसोसिएशन के भी आने वाले प्रेसिडेंट भी हैं, और आपसे पहले सेम क्वेश्चन हमने जेएम शर्मा से भी, वही सीनियर एडवोकेट है, उनसे पूछा था, सीनियर एडवोकेट रेड्डी साहब से पूछा था, जस्टिस बालाकृष्णन से भी और जस्टिस अजय रस्तोगी से भी 3 दिन पहले यही मैंने पूछा। सवाल हमारा ये था उन लोगों से कि 5 ईयर की जो कोर्स होती है LLB की, उसके करने के बाद 2 साल इंटर्नशिप करते हैं लड़के, फिर एग्जाम क्लियर करते हैं, 7-8 साल उनका चला जाता है। तो उनसे मैंने ये पूछा था कि हम लॉ लर्निंग बेंच में, जिसमें हमारे काफ़ी सीनियर एडवोकेट हैं सुप्रीम कोर्ट के और जजेज भी हैं रिटायर्ड, इसमें और क्या हम कैरिकुलम में ऐड कर सकते हैं आपके अनुसार। उन्होंने ऑल इंडिया बार काउंसिल को भी उन्होंने बोला है हमारे माध्यम से, वो लेटर भी लिखा है जैसे अजय रस्तोगी कि हम कुछ बोलेंगे, जो जैसे आपने बोला कुछ प्रैक्टिकल स्टार्ट करने के लिए। लेकिन सर, हम और क्या कैरिकुलम में ऐड कर सकते हैं आपके अनुसार, जो हमारे बिहार, यूपी और भी कई जगह से जो आते हैं और सुप्रीम कोर्ट में प्रैक्टिस करते हैं, उनको हम क्या सिखा सकते हैं इंटर्नशिप के अलावा सर? मतलब हमको कैरिकुलम में क्या ऐड करना चाहिए? दिस इज माय क्वेश्चन।
तो आप तो करिकुलम तो नहीं बनाते हैं, आपको तो वो अपना एक ये है।
हमारा करिकुलम है और सारा प्रैक्टिकल ट्रेनिंग पे, इसमें कोई बीआर एक्ट वगैरह तो लड़के पढ़ के आते हैं, लेकिन हम उसको ऐड जैसे आपसे हमने अनुभव लिया कि कैसे हम तैयारी करते हैं, कैसे प्रिपरेशन करते हैं, ये एक्चुअल ट्रेनिंग आप एक तरह से आपने हाई कोर्ट और सुप्रीम कोर्ट में प्रैक्टिस करने वाले तमाम लड़कों को अभी हमने एक्चुअल बताया कैसे उन्हें तैयारी करनी चाहिए। तो ये सब हर सीनियर एडवोकेट का इतना टाइम नहीं होता है कि वो बार बार मिलते, उनको हम अपने में क्या ऐड करें जिससे हम उन्हें कुछ फायदा पहुंचा पाए।
तो आपके अपने मॉड्यूल में जो आप जिस तरह का आपने बना रखा है, आई थिंक ये काफ़ी अच्छा है। इस तरह के लोगों से जो आप सवाल जवाब कर रहे हैं, इससे बड़ा भारी लर्निंग का क्वेश्चन इससे आता है।
तमाम लोग देख भी रहे
और
हैं।
इसी को आगे जब बढ़ाएंगे, आज के सेशन के बाद आपको जब अगले सेशन के पहले आपको कुछ बच्चों का सवाल आएगा, क्योंकि क्या है ना, अल्टीमेटली आपको ये समझने की कोशिश करनी है कि बच्चों के दिमाग में क्या है, और बच्चों के दिमाग में जो आपको सवाल और जो आते हैं, उसी सवाल के को जवाब खोजने के लिए आपको अगले सेशन में उसका तैयारी करना चाहिए, और उसी से आपका ये इम्प्रूवमेंट होता रहेगा।
थैंक यू सर, आपने इतने व्यस्त कार्यक्रम में से हम लोगों को समय दिया, और आपको आने वाले चुनाव के लिए बहुत बहुत शुभकामनाएं। और सबसे मैं रिक्वेस्ट करूंगा कि सर हमारे जो भी प्रयास कर रहे हैं हम लोगों के लिए, उसकी मैं सराहना करता हूँ सर, और आपको बहुत बहुत धन्यवाद।
थैंक यू सर।